Hi, this is Sean Bible, and this is a blog for Bible Law Firm. I just want to informally talk to you about a legal issue today, and that issue is a DUI arrest. And what happens if you're arrested and charged with DUI. There's basically two types of DUI prosecutions, a per se prosecution and a less safe prosecution. A per se prosecution is when the state will have evidence, blood, breath, urine, that go under the influence. You might have heard of the .08 limit. So if you were to blow .09, the state can get that evidence into court, into trial, they'll more likely be able to convict you if they can get that number into court. A less safe prosecution is one where they have to rely on your driving or bad driving or your field sobriety test, those results, and that's a less safe prosecution. Once you're arrested for DUI, basically the process, of course, you will go to jail. In most DUI cases, unless there's been a death, an injury, and a wreck, you'll get a bond fairly quickly. You'll then be given a court date. Sometimes, if your case is in one of the local traffic courts, that court date will be pretty quickly. If your case happens to be in a superior court or higher court for whatever reason, your court date can be several months away. If you get arrested for DUI, the first thing you need to do, of course, after you make bond and get out of jail, is to deal with any possibility of administrative license suspension, and I can't really emphasize that enough. What an administrative license suspension is if you do not submit to blood tests, breath tests after being asked. And what normally happens is if an officer arrests you for DUI and if they suspect that you're under the influence, they will usually pull out a little card. It's usually a little orange card called the implied consent card and ask for a sample of your breath, blood, or urine. Not always, but usually if the officer suspects you of drug use, they'll ask for a blood test. If alcohol, they'll ask you to blow on a breathalyzer. There's a portable breathalyzer they call the PBT, or Alka-Sensor can be the trade name of the device, so that they can test that at the scene. That's not admissible in the court. They'll want you to go back to the jail, sheriff's office, wherever the big machine is, the intoxilizer 5,000, 7,000, 9,000, it changes over time, but it's the intoxilizer machine. That's what can be admissible in the court. Or they can't ask for a urine test. We don't see that as much. So they can ask for a test of your blood, which is obviously an EMT will come to the scene, draw your blood, breath test on the intoxilizer machine, or a urine test, which we don't see as much of. If you don't submit to one of those tests, the state patrol or the deputy officer who arrests you can file what's called an administrative license suspension. And here's the thing you need to be worried about there. That administrative license suspension, that ALS hearing, you only have 10 days to object to that. So the officer will give you a little piece of paper. You won't really know, what it is. Most people aren't even aware of this, but it'll have some writing on the back. And it says you have 10 days to file an objection to an administrative license suspension. That means your license is going to be suspended administratively before you ever get to court. And you only have 10 days to object to it. So it's very important that you get with a lawyer within 10 days of a DUI arrest and make sure they know. The lawyer should ask, but you probably need to bring it up. Make sure they know if you've been given notice of administrative license suspension. That's the first thing and most important thing you need to do so you don't lose your license before you get a chance to go to court and defend yourself. The way the administrative license process works is that you have to send $150. The address is a location in Conyers for the Department of Driver Services. And then you send in basically, and there's certain things you have to tell them about. There's kind of a standard form you would send in that most attorneys send in. That's the reason but it is good to talk to an attorney. It's not something you probably need to do yourself. You send that in within 10 days. They will set you a court date in front of an administrative law judge. If you're in this circuit where I practice, look at Mount Judicial Circuit, that hearing will take place in the town of Lafayette in Walker County. And you're going for an administrative law judge there. The administrative law judge pretty much is going to be determining, and this will probably be several months after your initial arrest, or at least about 2 months. They'll be deciding not your guilt or innocence, but whether the officer followed the proper procedures, whether if your rights were violated, if anything that would keep that administrative license suspension from going through. But it's not technically determine whether you're guilty or not guilty. It's just determine whether the ALS or administrative license suspension was done correctly. I know that's a lot to take in, but basically what you need to remember, what you need to take from that is within 10 days of your arrest, If you're arrested for DUI, especially if you refuse the test, and even if you didn't, because there's some cases where they can suspend your license for a shorter period of time, even if you do comply with the test. You need to take away from this, talk to a lawyer within 10 days of a DUI arrest, or your license may be suspended before you ever get to court. The next step, obviously, you get an attorney, you'll have a court date. Sometimes usually you'll have an arraignment date first, where you plead guilty or not guilty, and then you'll have a trial date. Almost all criminal cases, including DUIs, are going to be resolved in one or two ways. Some kind of a pre-trial disposition is going to be reached. That could be maybe a dismissal of your case, but most of the time it'll be some kind of plea agreement, or you can ask for a trial. That trial can be a bench trial, which is a trial in front of a judge, or a jury trial. So at the end of the day, your DUI case, if you're arrested, you're either going to work out some kind of pre-trial agreement, some kind of plea, or you're going to go to trial. That's how 99% of these cases will be disposed of. Let's talk about if you do plead guilty. On a first DUI, what you can expect, depending on the court, depending on the prosecutor, depending on the facts of the case, is probation. If it's a first DUI in Georgia, it has to be 12 months probation, 40 hours community service, that can be reduced to 20, DUI school, possibly an alcohol and drug assessment, and possibly jail time. Some courts, if you've spent a night in jail on a first DUI, will just give you time served. Some courts, the offer will be up to 10 days in county jail. You will lose your driver's license, but if you're a Georgia resident, you can get what's called a temporary permit, or what used to be called a work permit. That allows you to drive really more than just work. You can drive to work, school, doctor, pharmacy, and they take children or dependents to the same places. After 120 days, you get your license fully reinstated. The license issues are really not dealt with in court. Those are dealt with Department of Driver Services. The court does not have a whole lot of control as far as when you get back your driver's license. But generally, most people charged with a first offense DUI will be eligible for a work permit for the first 120 days, and they'll be eligible to get their license back completely and reinstated after 120 days if they did DUI school. If you don't plead guilty, or if some kind of pretrial arrangement's not worked out, you'll go to trial. You'll have the choice of a bench trial, which is a trial in front of a judge. A lot of the lower courts, you'll see this. Especially if you're in Superior Court, though, you'll be having a jury trial, and that's a trial in front of a jury. In a misdemeanor case, unlike a felony case, it'll just be 6 people. If you're found not guilty, you walk out. It's like it didn't happen. If you're found guilty, there's a good possibility of increased punishment, unfortunately, more jail time, but all the same provisions if you plead guilty that I just talked about. The community service, the license suspension will still be in effect. That's a general outline of what you can expect from a DUI arrest if you've been arrested for DUI. The takeaways are, please remember within 10 days you need to talk to an attorney to make sure your license is not suspended before you go to court. You need to talk to an attorney certainly before you go to court for your arraignment, so you can decide whether your case is something that, where you need to just plead guilty, where you need to work out some kind of arrangement to enter disposition before trial, or whether you need to have a trial. But thanks for listening to the blog, and I'll be back next week with another episode about DUI law. Thanks.